हेलो एवरीवन, वेलकम टू कबीर हर्ष एकेडमी। देखिए, हम आज स्टार्ट करने वाले हैं ऑफ क्रिमिनल ट्रेसपास। सेक्शन 441 क्रिमिनल ट्रेसपास से शुरू करेंगे ऑफ आईपीसी। whoever enters into or upon property in the possession of another with intent to commit an offense or to intimate, insult, or annoy any person in possession of such property, or having lawfully entered into or upon such property, unlawfully remains there with intent thereby to intimidate, insult, or annoy any such person, or with intent to commit an offense, is said to commit क्रिमिनल ट्रेसपास। स्टेट अमेंडमेंट है, कर्नाटका का नहीं पढ़ना है। Then Odisha, not, not included. Then Uttar Pradesh, not included. Section 442 house trespass. Whoever commits criminal trespass by entering into a remaining in any building, tent, or vessel used as a human dwelling, or any building used as a place for worship or as a place for the custody of property is said to do commit house trespass. Explanation: the introduction of any part of the criminal trespasses body is entering sufficient to constitute house trespass. Section 443 lurking house trespass. Whoever commits house trespass having taken precaution to conceal such house trespass from some person who has a right to exclude or eject the trespasser from the building, tent, or vessel which is the subject of the trespass is said to commit lurking house trespass. 444 lurking house trespass by night. Whoever commits lurking house trespass after sunset and before sunrise is said to commit lurking house trespass by night. 445 housebreaking, important section. A person is said to commit housebreaking who commits house trespass if he effects his entrance into the house or any part of it in any of the six ways hereinafter described, or if being in the house or any part of it for the purpose of committing or an offense, or having committed an offense therein, he quits the house or any part of it in any of such six ways, that is to say, first, if he enters or quits through a passage made by himself or by any abettor of the house trespass in order to the committing of the house trespass. Secondly, if he enters or quits through any passage not intended by any person other than himself or an abettor of the offense for human entrance, or through any passage to which he has obtained access by scaling or climbing over any wall or building. Thirdly, if he enters or quits through any passage which he or any abettor of the house trespass has opened in order to the committing of the house trespass by any means by which that passage was not intended by the occupier of the house to be opened. Fourthly, if he enters or quits by opening any lock in order to the committing of the house trespass, or in order to the quitting of the house after a house trespass. Fifthly, if he effects his entrance or departure by using criminal force or committing an assault or by threatening any person with assault. Sixthly, if he enters or quits by any passage which he knows to have been fastened against such entrance or departure and to have been unfastened by himself or by an abettor of the house trespass. Explanation क्या है? Any outhouse or building occupied with a house and between which any and such house there is an immediate internal communication, is part of the house within the meaning of this section. Illustration: A commits house trespass by making a hole through the wall of Z's house and putting his hand through the aperture. This is housebreaking. Then section 446, housebreaking by night. Whoever commits housebreaking after sunset and before sunrise is said to commit housebreaking by night. Chapter 18 of offences relating to documents and to property marks. Section 463, forgery, important section. Whoever makes any false document or false electronic record or part of document or electronic record with intent to cause damage or injury to the public or to any person or to purpose to support any claim or title or to cause any person to part with property or to enter into any express or implied contract or with intent to commit fraud or that fraud may be committed commits for forgery. Conviction for making of false documents. Section 463 defines offences of forgery, while Section 464 substains the same by providing answer as to when a false document could be said to have been made for the purpose of one of the ingredients of forgery. Section 464, making of false document. A person is said to make a false document or false record first who is dishonestly or fraudulently: A. Makes, sign, seal, or execute a document or part of the document. B. Makes or transmit any electronic record or part of any electronic record. Affix any electronic signature or any electronic record. Makes any mark denoting the execution of the document of the authenticity of the electronic signature, with the intention of causing it to be believed that such document or part of a document, electronic record or electronic signature was made, signed, sealed, executed, transmitted, or affixed by or by the authority of a person by whom or by whose authority he knows that it was not made, signed, sealed, executed, or affixed. Or secondly, who without lawful authority dishonestly or fraudulently, by cancellation or otherwise, alter a document or an electronic record in any material part thereof after it has been made, executed, or affixed with electronic signature, either by himself or by any other person, whether such person be living or dead at the time of such alteration. Then, thirdly, who dishonestly or fraudulently causes any person to sign, seal, execute, or alter a document or an electronic record or to affix his electronic signature or any electronic record, knowing that such person by reason of unsoundness of mind or intoxication cannot, or that by reason of deception practiced upon him he does not know the contents of the document on electronic record or the nature of the alteration. Illustration: A has a letter of credit upon B for rupees 10,000 written by Z. A, in order to defraud B, added a cipher to the 10,000 and makes the sum 1 lakh, intending that it may be believed to by B that Z so wrote the letter. A has committed forgery. A man's explanation: a man's signature of his own name may account to forgery. Illustration: A signs his own name by a bill of exchange, intending that it may be believed that the bill was drawn by another person of the same name. A has committed forgery. Explanation 2. The making of a false document in the name of fictitious person, intending it to be believed that the document was made by a real person, or in the name of a deceased person, intending it to be believed that the document was made by the person in his lifetime, may amount to forgery. Illustration A draws a bill of exchange upon a fictitious person and fraudulently accepts the bill in the name of the such fictitious person with intent to negotiate it. A commits forgery. Note, Section 21D of the IT Act defines affixing digital signature as follows. D क्या कहता है ये देख लीजिए. Affixing digital signature with its grammatical variation and cognate expression means adoption of any methodology or procedure by a person for the purpose of authentication an electronic record by means of digital signature. 465 Punishment of forgery. Whoever commits forgery shall be punished with imprisonment of which may extend to 2 years and with fine or with both. 497 Adultery. Important section. Whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man without the consent of convenience of that man, such sexual intercourse not amounting to the offense of rape is guilty of the offense of adultery and shall be punished with imprisonment of either description for a term which may extend to 5 years or with fine or with both. In such cases, the wife shall not be punishable or as an abettor. Constitutional validity. Section 497 is struck down as unconstitutional, being violates of Article 14, 15, and 21 of the Constitution. However, if an act of adultery leads to suicide of aggrieved spouse, the adulterous person can be prosecuted under Section 306 IPC for abatement of suicide. Joseph Shine versus Union of India 2019 का केस लॉ है.